Hello, today's case is a real important one because it affects everybody that has any kind of litigation, any kind of court case. It is a case about a lake. It is a case about a seawall. And everybody that knows me knows I love going up to Lake Wawasee. Been going there my whole life, hanging out on the boat. In fact, a couple weeks ago, Mom and Dad were here and we had literally 4 generations on the boat. It was fantastic. So Mom and Dad and me and Gina, our daughter Kelly, and our granddaughter Stella, one of her friends, out on the wakeboard. It was very awesome, totally fun that day. And just having 4 generations on the water is fantastic. So this case is near and dear to my heart because it's a lake case. And this particular person, what was in dispute was he applied for a permit with his city or town or county in order to install a seawall around his property and protect it from the water. So a lot of lakes have a seawall. Wawasee is one of those where there's a seawall all the way around, and it helps absorb the waves and whatnot, and helps protect the shoreline. So this case went back and forth, back and forth, back and forth from an administrative matter, a town matter, a trial court matter in front of an administrative court, finally up to the Court of Appeals. And what the Court of Appeals decided is that he didn't prove his case, that he needed a seawall, and he didn't prove it because he didn't prove that his area of the lake had been developed. And the key issue was whether or not there was development, and that would then allow the seawall to be there. If there was no development, then no seawall needs to be allowed by the city. And he presented some overhead photographs, and he presented a couple witnesses that were disinterested. But the Court of Appeals decided the most important thing was the experts from the state, and that the trial court had used its proper discretion and weighed the evidence appropriately, had heard all the evidence, and it was in the best position to decide it. So always remember, word to the wise, always remember that the case at trial is the most important because that's when you get your evidence in. If you don't have your evidence in, if you don't bring that witness, if you don't kind of overdo it, maybe having more engineers, more water studies, more samples, more measurements, that kind of a thing, that would have really helped out this property owner. He didn't have that. He didn't have anything to support it. And the Court of Appeals noted that it was very important at the trial court level that the vegetation around the lake could appear quite differently at different times of the year. The water level can be very different according to rainfall and runoff and whatnot, that it wasn't really clear whether the lake had been expanded with dredging activity. It just was, they just couldn't, put their fingers on it and say, yes, really this was developed, or no. And because it was the property owner's burden of proof to figure it out, he didn't meet his burden, and the trial court was upheld. So the bottom line answer to all that today is when you have litigation, it's all about proof, proof, proof. I beat this into the ground every time I do a case like this. We talk to judges all the time, and they always say document, document, document. That's the key to winning a case in their court, because it's the only thing that's objective they have to go on. And they only know what you tell them. Judge Garland Graves over on the east side in small claims court, he says, this is your constitutional right to be in front of a court. Use it wisely. He always says that. And I think it's the best thing I hear in any of the small claims courts, not to say bad about anybody else, but I think it's a neat way that he presents that this is your day. This is your constitutional right to a trial. This is your opportunity for presenting evidence. You got to speak up. You got to say your mind. You have to present your evidence. You got to have your witnesses there. And if you wait and say, well, I could have had a witness about that, I could have gotten a picture of this or that, then, it's too late. Just like this property owner, he could have maybe presented his case in a different way and won, but he did not. And that's what tripped him up. So evidence, that's what wins cases. Proven again by our Court of Appeals. Judge Cale Bradford did that. Great justice. So a very good opinion. Enjoy. I'll post the site for it. Thank you.